Good afternoon. This panel will discuss Justice Scalia on federalism and separation of powers. Now, Justice Scalia's views on this subject were fairly well known. In 2008, he authored a foreword to a symposium on the separation of powers as a safeguard of federalism in the Notre Dame Law Review. His foreword, entitled "The Importance of Structure in Constitutional Interpretation," left no doubt what Justice Scalia's view on the subject was. I'd like to read a couple of paragraphs of what Justice Scalia said in that foreword. In the days when I taught constitutional law, the University of Chicago Law School had two constitutional courses. One was entitled Individual Rights and Liberties and focused primarily upon the guarantees of the Bill of Rights. The other, I forget the title of it, focused upon the structural provisions of the Constitution, principally the separation of powers and federalism. That was the course I taught, and I used to refer to it as real constitutional law. The distinctive function of a constitution, after all, is to constitute the political organs, the governing structure of a state. Many of the personal protections against the state taught in constitutional law courses here, restrictions upon unlawful searches and seizures, for example, used to be taught in Europe as part of administrative law. They were, to be sure, made part of our Constitution, though most of them as an appendage to the original document. And that was no doubt desired, but it is a mistake to think that the Bill of Rights is the defining or even the most important feature of American democracy. Virtually all of the countries of the world today have bills of rights. You would not feel your freedom secure in most of them. Consider, for example, the following sterling provisions of a modern Bill of Rights. Every citizen has the right to submit proposals to state bodies and public organizations for improving their activity and to criticize shortcomings in their work. Persecution for criticism is prohibited. Persons guilty of such persecution shall be called to account. Citizens are guaranteed freedom of speech, of the press, and of assembly, meetings, street processions, and demonstrations. Exercise of these political freedoms is ensured by putting public buildings, streets, and squares at the disposal of the people and their organizations, by broad dissemination of information, and by the opportunity to use the press, television, and radio. And finally, citizens are guaranteed freedom of conscience, that is, the right to profess or not to profess any religion and to conduct religious worship or atheistic propaganda. Incitement of hostility or hatred on religious grounds is prohibited. Justice Scalia wrote, "Wonderful stuff." These were the provisions of the 1977 Constitution of the Union of Soviet Socialist Republics. They were not worth the paper they were printed on, as are the human rights guarantees of a large number of still extant countries governed by presidents for life. They are what the framers of our Constitution called parchment guarantees, because the real constitution of those countries, the provisions that establish the institutions of government, do not prevent the centralization of power in one man or one party, thus enabling the guarantees to be ignored. Structure is everything. Justice Scalia often said that while he always tried to get the Bill of Rights cases correct, he cared most about the constitutional structure cases. Once or twice each summer, he even taught a course called Separation of Powers. His opinions on the structural issues of separation of powers and federalism often cited the Federalist Papers. He routinely urged law students and lawyers to read the whole of the Federalist. This panel looks at Justice Scalia's Federalist focus on the importance of separation of powers and federalism as structural protections of liberty. And as usual, the Federalist Society has assembled a terrific panel to discuss these issues. I will introduce each of the panelists in the order in which they will speak. They will each speak about 8 minutes, and then we'll have some responses to each other, and then we'll begin entertaining questions from the floor. Our first speaker, very fittingly, is Professor John Baker. Dr. Baker has been a visiting professor at Georgetown Law School and is a visiting professor at Peking University School of Transnational Law. He is Professor Emeritus of Law at the Louisiana State University Law School. He has also taught at a number of other law schools, I should note, including Tulane. Professor Baker received his JD with honors at the University of Michigan Law School and his Bachelor of Arts magna cum laude from the University of Dallas. He also earned a PhD from the University of London. For several years, Professor Baker taught the course for the Federalist Society on separation of powers with the late Justice Scalia. Our second speaker is Professor Jonathan Turley. It's going to be Tulane Day. Jonathan Turley is a nationally recognized legal scholar who has written extensively in areas ranging from constitutional law to legal theory to tort law. He began his teaching career at Tulane Law School and then joined the George Washington University faculty in 1990, and in 1998 became the youngest chaired professor in the school's history. He is the founder and executive director of the Project for Older Prisoners. He has written more than 36 academic articles that have appeared in a variety of leading law journals, including those of Cornell, Duke, Georgetown, Harvard, and Northwestern, among others. He most recently completed a 3-part study of the historical and constitutional evolution of the military system. He has served as a consultant on Homeland Security and constitutional issues and is a frequent witness before the House and Senate. Professor Turley received his undergraduate degree from the University of Chicago and his law degree from Northwestern University. And his first job out of law school was a law clerk on the United States Court of Appeals for the Fifth Circuit, where yours truly was clerking for a judge that year as well. So we go way back. Luther Strange is the Attorney General of Alabama, a high post in government. Before his election, General Strange practiced law in Birmingham, Alabama, and before establishing his own law firm, was a partner with Bradley A. Rambolt Cummings. He is the chairman of the Republican Attorneys General Association. He also served as the court-appointed coordinating counsel for the Gulf Coast states in the historic Deepwater Horizon oil spill litigation. General Strange is well educated. He received both his undergraduate and law degrees from Tulane. He was a scholarship basketball player while earning his undergraduate degree at Tulane. In June of this year, he was inducted into the Tulane Law School Hall of Fame. Roger Pallan is the founding director of Cato's Center for Constitutional Studies. He's also the founding publisher of the Cato Supreme Court Review and the inaugural holder of Cato's B. Kenneth Simon Chair in Constitutional Studies. Before joining Cato, Roger held several senior posts in the Reagan administration, including at State and Justice, and was a national fellow at Stanford's Hoover Institution. Roger holds a BA from Columbia University, an MA and PhD from the University of Chicago, and a JD from the George Washington University School of Law. And finally, Congressman Ron DeSantis. Since being elected to the United States House in 2012, Congressman DeSantis of Florida has served on the Judiciary, Foreign Affairs, and Oversight and Government Reform Committees. He is the chairman of the Oversight Committee National Security Subcommittee and the vice chairman of the Judiciary Committee's Subcommittee on the Constitution and Civil Justice. He earned a Bachelor of Arts, magna cum laude, and was the captain of the varsity baseball team at Yale, continuing the athletic theme. He also graduated with honors from Harvard Law School. While at Harvard, He earned a commission in the United States Navy as a JAG officer. During his active duty Navy service, he served as a military prosecutor, supported operations at the terrorist detention center in Guantanamo Bay, Cuba, and deployed to Iraq during the 2007 troop surge as an advisor to a U.S. Navy SEAL commander in support of counterinsurgency operations in Iraq. He's also performed duties as a federal prosecutor, taught courses on military law, and written on constitutional issues. He's currently a lieutenant commander in the U.S. Navy Reserve. Thank you for your service. We will begin with Professor Baker.
Thank you, Judge. In this convention, you will hear a number of references to Justice Scalia's lone dissent in the 1988 decision in the independent counsel case, Morrison v. Olson. That dissent went from being largely dismissed to being universally celebrated. Ed Whalen, in a piece in the National Review Online last month, or in September, chronicled the movement of Linda Greenhouse to a conversion. Ms. Greenhouse now describes Justice Scalia's dissent as, quote, prescient. That means far-seeing, prophetic. Liberal columnist Richard Reeves used the same word, prescient, in praising Justice Scalia's dissent in Morrison back when Ken Starr was investigating as independent counsel President Clinton. I think there was a connection there that caused some rethinking here. For the most part, however, liberal commentators have not praised Justice Scalia's opinions. Most often, detractors have used the word uncompromising in a negative way to describe the justice's opinions. Of course, admirers, as you heard from Justice Alito this morning, use the word uncompromising in a very praiseworthy sense in talking about Justice Scalia. What the usual detractors do not understand is that Justice Scalia was able to be prescient, far-sighted, prophetic, precisely because he was uncompromising in looking backwards. Now, of course, virtually everyone knows that Justice Scalia looked back to the public meaning of the words of the Constitution as understood at the time they were drafted. Also, most here in this convention will know that Justice Scalia's originalism was tied to constitutional structure, as Judge Pryor just talked about. But how many of you, even here, realize that his understanding of structure came largely from the Federalist Papers? That's what I want to discuss, and I'll make 3 points. Hopefully I'll get to the third one. The importance of Justice Scalia's place on the Federalist Papers. 2, how Justice Scalia's understanding of the constitutional structure, primarily separation of powers, as explained in the Federalist, undergird his approach to the text of the Constitution. Time permitting, I'll mention something about federalism. First, on the importance of the Federalist, as you've already heard, Justice Scalia would routinely ask students and lawyers in meetings or groupings, have you read the Federalist? And then some hands would go up, and he said, no, I mean the whole Federalist. And most of the hands would go down. His materials in the course that we taught, that he taught as well every summer on separation of powers, always began with Federalist 47 and 48. Those are the main ones on separation of powers, although separation of powers runs throughout the essays of the Federalist. And usually after we got done with that, then he would go into an attack on the progressives and their attack on separation of powers. Often it was an attack on Justice Cardozo's reference to separation of powers as, quote, a fetish. Last time, he taught, it was a sustained dialogue, one might say diatribe, against Woodrow Wilson and his attack on separation of powers as being terribly outmoded. Early on in our relationship, I asked him when was it that he came to really pay attention to the Federalist. And he said it was when he was head of OLC, because he said the questions we were dealing with, there was no case law. Where would you turn? Well, like the founders, like the first generation, like the Marshall Court. Where do you turn? Well, you turn to the text. But in many ways, the text is like the building plan, and it doesn't always explain exactly how things lock together when they could lock together in different ways. Understanding that is really part of the context in which his originalism and his textualism must be understood. Some of the examples, as many law professors have taught over the years, they've taught that Marbury, is this great triumph of Chief Justice Marshall figuring out very cleverly how to get around Jefferson. Well, as Leotis has written in class, before he was on the bench, then Professor Scalia would explain how this is really how the Constitution as supreme law is supposed to work. Now, this can give textualists some problems because there is nothing in the text that says judicial review or what the court's power shall be. It says about the rule of law, and it says about its jurisdiction. But in our seminars, he would be much more simple about it. He would just say, Marshall plagiarized Federalist 78. That's simple. Now, the fact is you can take most of the landmark opinions of the Marshall Court, even though they did not cite the Federalist, and they're straight out of the Federalist. But this question of whether it is or isn't out of the Federalist has to do with the legitimacy and limits of judging. Think about it. There are many conservatives who believe that somehow judicial review is illegitimate. And if it's illegitimate, then the choice is, well, are you going to be slightly illegitimate and restrained, or are you going to be fully illegitimate? It's kind of like being partially pregnant. It just is hard to restrain from going from partially to fully. And if, however, you understand separation of powers as he did, then there are times when you are forcefully, uncompromisingly limiting the power of one of the other two branches. But that doesn't make you an activist. And he really didn't use that term. It is a question for him of following the text, but text as tied to the structure. 2, his citations to the Federalist were not just window dressing. There was an article in the William and Mary Law Review in which a professor suggested that almost every time a Supreme Court justice cites the Federalist, it's really much about nothing. That was not the case with the justice, and you can see it if you read and analyze and compare, for instance, in Morrison v. Olson, the majority opinion written by the Chief Justice and the dissent. So if you look at that, what you will see, first of all, what's remembered are all the great one-liners. And I heard it at lunch, and one of the things, a wolf comes as a wolf. That's what people remember. And when he was hailing the demise in a way of what's the, anyway. He said, I'm glad to see that those who live by the ipse dixit die by the ipse dixit. But he used those memorable phrases in order to get you to pay attention to what he was actually saying. And what he wants you to do is look at the way he argues as compared to the way they argue. In many ways, the Chief Justice in that case was the textualist, because he starts out with the Appointments Clause, doesn't mention separation of powers. Then he goes to the removal. There's no clause on removal. It goes back to a famous decision in 1789 in the Congress. And then he goes through all the cases. And then at the very end, he says, well, what about separation of powers as a whole? Justice Scalia's dissent is the flip of that. He starts with the principle of separation of powers. Then he works through it. Completely different approach in terms of where you start. Now that can pose a problem for some textualists, because they say, you could say, where is separation of powers even in the Constitution? There's no term there. That term appears in the 1780 Constitution of Massachusetts. It doesn't appear in our document because it's a blueprint. It's not an explanation. The Federalist is the explanation of the blueprint. I wasn't going to spend much time on federalism anyway, because although he got the federalism decisions right, he didn't much focus on them. Why? Well, as he said one time, the 17th Amendment, direct election of senators, basically killed federalism. He also said, if the people won't preserve federalism, don't expect federal judges to preserve federalism. But more importantly, in a way, some of the important federalism cases are also separation of powers cases. Think of the sovereign immunity 11th Amendment cases. It's the states, it's the federal government, Congress enacting something. Think about Obamacare. Federalism is really the joinder of federalism and separation of powers. In conclusion, Justice Scalia's lone dissent in Morrison against the dilution of presidential power as given in Article 2 ultimately was vindicated. It will be interesting to see whether the constitutional limits on the expansion of presidential power will be vindicated. Although Justice Scalia died before the 4-4 split in U.S. versus Texas on the issue of President Obama's order improperly allowing deferred action on the illegal aliens, I don't think that there's much doubt about how he would have voted in that case. So I wouldn't be surprised to see justices who have taken, so far, a flexible approach to separation of powers suddenly become uncompromising about separation of powers as applied to limits on presidential power during the presidency of Donald Trump. Thank you very much.
First of all, I'd like to thank the Federalist Society again for the honor to speak with you today. It's a particular honor to appear with my former co-clerk, Judge Pryor. You know, the strongest memory I actually have of him from when we clerked together on Fifth Circuit is my judge and his judge sat in the same panel, and there was one case that was just an unbelievably sexy constitutional case. And John Minor Wisdom was already senior status, and so my judge technically was the head of the panel. And so I spent the entire week, because my judge would often defer, because he's a very, very nice guy. And I said, you got to grab the case. You're both going to be on the same side. Don't let Wisdom get the case. Just grab, please, for the love of God, please. And so I'm walking with him towards conference, and I'm saying, all you have to do is grab the case. Just say you'll grab the case. He'll let you grab the case. And I come around the corner, and there's Pryor talking to Wisdom feverishly. And Pryor looked up with the most menacing look I've ever seen in my life. And sure enough, they wrote the opinion, and I've been bitter about it ever since. And so thank you for this cathartic moment.
Pure fiction.
Yeah. Anyway, it's a great honor to speak about Justice Scalia. Scalia and I shared a Sicilian heritage. I'm half Sicilian, half Irish, much like his kids, which I reminded him of when he would make fun of me. And when Justice Scalia passed away, the Washington Post called me and said, do you have any memories you'd like to share? And the only one that came to mind was we were at this dinner for a Sicilian senator, and we were standing by this bay window, and Justice Scalia was holding forth on a story, and the Sicilian security guards kept on trying to move us away from the window, and Scalia wouldn't move. And the security guards tried this. Finally, the guy turns to me and says, why won't he move? We're afraid there's a hit team that's looking for the Sicilian senator, and we're afraid that they're in danger at this window. And I said, the reason is that Justice Scalia is telling a story. And I'm pretty sure that he'd rather die than end the story, but I know he'd rather one of us die. But the fact is, I thought about that story only because people have been trying to move Scalia to the left or the right his entire life. He never did move. He was one of the few justices that could honestly say that he changed the court more than the court changed him. And the reason is because he came to the court with a very profound sense of the Constitution and its history. One of the things that I think gave him that foundation, that legacy, was that he based his opinions heavily steeped in the Federalist Papers. He also had a formalist approach to the Constitution, which I'm going to mention in a second. I share that approach. I'm sort of in a minority among academics in believing in a formalist approach to separation of powers. Most academics view that view as naive and simplistic. In fact, I just gave a speech at Georgetown where one of the questions was, you do accept, right, that words have no objective meaning. And there was a time when a statement like that would have left me entirely confused. Then I remembered I was at Georgetown. The fact is that the original deal that was struck with the American people is those words did have meaning. And while some of my colleagues view it as a precious lie, it was the original lie that the American people were given. And Scalia saw it that way, and it added a depth and coherence to his opinions. It's, for me, the really most indicative and profound opinion that he wrote was in Prince. And that, of course, was an early methodological demonstration of what we became quite familiar as Scalia's analysis. He famously said in that opinion, because there are no constitutional texts speaking to this precise question, the answer to the challenge must be sought in historical understanding and practice. When you look back at that statement and you see what came after it, you realize how profound that was. He tended to run home. He tended to run home to the Federalist Papers. He tended to run home to the text and to the original meaning. And in that decision, of course, in Prince, you had this wonderful clash between Scalia and Souter over the Federalist Papers. And they debated the meaning of numbers 27, 36, 44, and 45. What was interesting is that even Souter acknowledged that the meaning within those Federalist Papers would or should be given great weight in the analysis of the case. This case dealt with having state officials who would be required to carry out federal functions or duties. And so what happened was this wonderful exchange, and quite frankly, Scalia, in my view, got the better of the exchange as to what was meant by this structure. And it was Scalia who would often talk about the dual sovereignty of federalism, this concrete notion of the relationship of the federal government to the states. And that sense of clarity, that formalistic approach, was also evident in Morrison, as was just discussed. And I'm not going to discuss it further since it was just discussed by John. But in that case, I'll simply note that once again, when he answered the question, which he said that opinion was one of his most difficult, he went back to the Federalist Papers and quoted Federalist 51 when Publius said, as the weight of legislative authority requires that it should be thus divided, the weakness of the executive may require, on the other hand, that it be fortified. And so he was very conscious of these lines, and that's one of the reasons I like his work so much. I happen to believe that words do have meaning in the Constitution, despite my own personal policies and interests. I think there are parts of the Constitution that have static meaning. They must have static meaning. There's others that might be a little more fluid, but when it comes to the separation of powers and federalism, those are static concepts that should not change through time. And in that sense, Scalia was the rock that would bring us back to that original meaning. And so Scalia did, in fact, refuse to compromise because he had principles. And that's particularly why he will have a legacy. There are many justices that came before him, and I'm afraid that could follow, that will not be able to make that claim. He was coherent and he was consistent because he had principles. People often criticized him as dogmatic, but you're supposed to be dogmatic on principles, because if you're not, you're what we call unprincipled. And so when he passed, I felt that not only did we lose a judicial icon, and also a wonderful human being. I don't know anybody that ever knew Scalia that didn't like him. He was remarkably likable. He would try to get into a fight with anybody over any subject because he really liked law students. If there was a pet in the room, he'd try to argue with the pet. Because he was vivacious, he was intellectually alive, and that's what comes out of these opinions. And he was a great believer in a formalist separation, not just in the separation of powers, but in terms of federalism. And so when he left, I remember thinking about a wonderful Quaker saying that said, quote, "I shall pass this way but once. Any good that I can do, or any kindness, let me do it now. Let me not defer nor neglect it, for I shall not pass this way again." Scalia didn't wait, he didn't compromise, he did what he could, and he remained confident about it and committed to it. And because of that, his like may not come this way to pass for some time, but there are many people who do cherish the legacy that he left, respect the principles that he represented, and will carry on those very same principles in the future, I believe. Thank you very much.
Thank you, Jonathan. And I'm going to take the risk of standing up at this podium, although I'm pretty far away from it. I hope you can hear me all right. It's just an incredible honor to be here, and I want to thank the Federalist Society for inviting me, including me in this distinguished group of colleagues and friends and people I admire and people I've known for a long time. It's wonderful to be the Attorney General of the state of Alabama in this time in our nation's history, to be a conservative Attorney General from any state. And I get to follow in the footsteps in an office that was really formed by my close friend Jeff Sessions and my close friend Bill Pryor, who really set an example that I have tried to follow in my years in the office, the 6 years that I've been there, 6 very active years. You know, I met Bill many years ago, and at the advice of Jeff Sessions, he said, you need to encourage young conservatives who want to run for office and be involved in the debate. And I didn't know what that really meant. I had volunteered for Senator Sessions when he had pulled a great political upset in Alabama. And so somehow or another, I guess nobody else would do it or could do it. Or I ended up being the chairman of Bill's election campaign when he took Jeff's place. And I'll never forget walking the halls. We stayed up all night on election night. And the judge knows the exact total of his victory. But it was something like, how many votes was it?
6,767.
6,667 out of over 2 million votes.
1.3 million.
Maybe 3 million. Suffice it to say it was close. As a matter of fact, AP hadn't called it. We were up literally all night walking the back room of the ballroom, wringing our hands, and we just finally decided, the candidate did, that we're just going to go out and declare victory and make them prove that we didn't win. And of course, he did win, and the rest is history. When Bill was Attorney General, Judge Pryor was Attorney General in this country not long ago, really. There were maybe 6 or 7, less than 10 Republican Attorneys General in the United States. Now there are 29 after last Tuesday's election. 29 conservative Republican. I was proud to be elected the chairman of that group last weekend at our meeting in Austin. You know, 2 weeks ago, actually the Thursday of the election, Kim Strassel, who's going to be here Saturday morning to sign her book, which I urge you to do, wrote an article in the Wall Street Journal, and she said, the conservative Republican Attorneys General of the United States are the last line of defense in protection of the Constitution and the rule of law. Of course, the world changed then, and frankly, my remarks today changed a little bit after that election. We're no longer the last line of defense. We're now the tip of the spear. But the whole issue, and why I said it's been an historic time to be an Attorney General, you know, the oath we take, all elected officials take, is to uphold the Constitution of the United States, of your respective state, and to uphold the rule of law. Politicians come and go. Some we'd like to go sooner than others, but they all eventually come and go. It's what preserves our liberties, our freedoms, our rights, our opportunities, our economy, everything that we enjoy in this country is the Constitution and the rule of law. Bart Brnovich in the previous panel said it very nicely. We don't get to pick and choose the laws we like and don't like, the ones we want to enforce and not enforce. There's a democracy set up for that purpose, and it works extraordinarily well if we protect it and preserve it. Now, we're talking about federalism today, and we'll hear from Congressman DeSantis and others about what we understand about horizontal federalism, the balance of power in our country. One of the things that I've hoped for quite some time now is that Congress would find a way to reassert its proper role in our balance of power here in Washington. I think a lot of power has been given away. That's led to a lot of problems that we've had to address, and I have great hope about that. But there's also the vertical separation, the states versus the federal government. And that's where we attorney generals have been very active in the last 6 years, really 8 years. I don't have the precise number. Dozens of lawsuits have been filed by conservative attorneys general across this country against the Obama administration over the last number of years for violating the rule of law, for exceeding the powers that Congress granted to them. And we've studied the breach, and we've won. And I mentioned the last line of defense. I'll just mention 3 cases that sort of illustrate the point. One has to do with bathrooms. I really never thought when I was elected Attorney General that I would be litigating in federal court about bathrooms. But the Department of Education, in its wisdom, decided that all schools should require all people, depending on their own definition of their sexual orientation, to use the bathroom of their choice or face the loss of federal funds. That was done in May 13th of 2016. On May 25th, 11 states challenged that rule in federal court, and on August 21st, a nationwide injunction was secured 3 months after the initial action. I'll just editorialize here because I was curious when that issue was brought to my attention, and I asked one of our school administrators, I said, is this a problem? Is this really a significant problem that requires a federal mandate? And you might not be surprised if you live in the real world that this supervisor said, actually, that's not a problem at all. This occasionally happens in our school systems, and we do something really revolutionary. We have the teachers and the parents and the students and the administrators all sit down and see if we can work out an accommodation that works for everyone, and that's exactly what we've done. It is not a problem. It is a problem for 99.9% of the other parents who don't understand this when the federal government mandates something like that. So regardless of that, we were successful in that. Immigration, it was mentioned earlier. The President issued his order in November of 14 to legalize millions of immigrants in this country. Less than 2 weeks later, 17 states filed a lawsuit challenging that action. And then on June 23rd of 16, 2 years later, in a 4-4 tie, the Supreme Court put an end to the President's effort. And then the last one I'll mention, because it's particularly relevant to our discussion about Justice Scalia, the Clean Power Plan rule, tremendously important to my state, to many states in this country. The EPA issued their rule in October of 2015. On that same day, 23 states filed a challenge to that ruling in federal court. And on February 9th, the Supreme Court stayed the Clean Power Plant rule, which was quite extraordinary. That was the last vote, official act of Justice Scalia. So it was critically important. We owe so much to his legacy. My final hope here that I'll express is that the Congress and the new administration will find a person who will fill the role that he has played in his shoes in the coming days, months, and as they deliberate that. We Republican AGs look forward to that because I'll get back to where I started. Regardless of who's the president or who's in Congress, we will continue to take our role seriously, which is to defend the Constitution and uphold the rule of law in this country. I really, again, appreciate this opportunity to be here, and I look forward to your questions and our discussion. Thank you.
Well, I too want to thank the Federalist Society for inviting me here. When Dean Reuter called me to see if I'd be interested in speaking, he said he wanted some balance on the panel. Balance, I thought, well, you must have read my foreword to the new Cato Supreme Court Review, which was titled Justice Scalia's Originalism, original or post-New Deal. So I think you know where that went. And so I am going to bring a little balance. I'm going to be I hate to be the skunk at the garden party. Well, actually, I don't. Hey, now that I think about it, but I loved Nino Scalia. Every time I ran into him, we got into an argument. He loved to argue, just loved it. And I mean, if you took one position, he'd take the other, and then you'd flip around. It was just great fun to argue with him. But for our subject here today, which is federalism and structural protections, he was absolutely right that the structural protections for liberty are the main protections for liberty. And he was correct also that the Bill of Rights was an afterthought, as he often said. Unfortunately, too often he ignored the changes the Civil War amendments made to those structural protections because he too little regarded the theory that undergirds the Constitution, and that led him to place democracy over liberty. That undergirding theory, state of nature theory, can be seen in the preamble, before that in the Declaration, and before that in Locke's second treatise, of course. But Scalia wouldn't go there. Ever the positivist, he dismissed it as philosophizing, unlike what he called the Constitution's operative provisions. His method was textualism, originalism, and structuralism, all salutary if you follow it, which he didn't always do. But those tools are often insufficient, of course, when you get to broad or vague text. At that point, you have to have a theory of the matter. You have to know where you're going. You have to know in particular what the presumption is. A judge can't simply throw up his arms and say, let the people decide, unless the text clearly points that way. The Constitution, after all, this Constitution, which a judge takes a duty to uphold, was written not simply to empower officials, but to limit them as well toward liberty, not simply toward power, as the preamble and the Declaration make clear. The bedrock principle, in short, is liberty. Reflecting the state of nature reasoning of the second treatise and the Declaration, the preamble begins by recognizing that sovereignty rests with the people. Government doesn't give the people their rights. They create the government to secure their rights. And toward that end, the framers structured powers. They divided powers between the federal and the state governments, leaving most of it with the states. And they separated powers functionally at the federal level, pitting power against power, as the Federalist shows throughout. Most important, though, they limited federal power through the enumeration of powers for a few national concerns. And to make that crystal clear, when they added the Bill of Rights, they concluded with the Ninth Amendment, which states plainly that we retained all the rights we never surrendered, and the 10th Amendment, which makes it equally plain that the federal government has only the powers we gave it. In a nutshell, the Constitution establishes a government of delegated, enumerated, and thus limited powers, further limited by our rights, both enumerated and unenumerated. For all its virtues, though, the original design was fatally flawed, as we all know. The Civil War amendments fixed that by fundamentally changing federalism, mainly through the 14th Amendment's Privileges or Immunities Clause, which made rights good against the federal government, including natural rights protected under the Ninth Amendment, good against the states as well, save for those rights peculiarly related to distinct federal and state functions. But we all know what happened to that clause and what happened 6 decades later when the New Deal court turned that carefully wrought design on its head by eviscerating the enumerated powers principle, bifurcating the Bill of Rights and the role of the court, judicial review, and jettisoning the non-delegation doctrine. So rather than rehearse those developments here, I'll return to Justice Scalia's view. A textualist cannot, of course, ignore the plain text, but he does. I'll start with a few powers cases where he tends to be better than rights. In fact, I'll start with an anecdote. I invited Nino over to Cato in 1993, and with the idea of going toe-to-toe with him on the issue of the demise of the doctrine of enumerated powers. Before we got that, however, he said, "Where's the wine?" I said, "This is lunch." He said, "So?" So we had to send an intern out to get a bottle of wine, and that loosened our respective tongues, as if either of us needed that. And we proceeded from there. And I did say to him at one point, "Nino, when are you going to revive the doctrine of enumerated powers?" "Oh, Roger, we lost that battle a long time ago." I said, "Well, thank you for that counsel of despair." But 2 years later, when Lopez came down, he was on the right side, as he was in Morrison when that came down 5 years later. And in Prince, as John Turley said, he wrote for the court in that case, saying that the Congress had no power to dragoon federal officials into carrying out state officials into carrying out federal functions. But 8 years later, in Raich, the California medical marijuana case, he read the Commerce Clause's power so broadly that Madison in Federalist 42 and Marshall and Gibbons would never have recognized it, as Justices Thomas and O'Connor made plain in their separate dissents. But in Scalias v. King, the two big Obamacare cases, he redeemed himself, albeit in dissent. Even the correctly decided powers cases, however, only scratch the surface of the enumerated powers doctrine. We're far down the road toward massive unconstitutional government, and I'm the last to think that the court by itself is going to reverse that. In the rights cases, however, we're more promising, except that here Scalia is altogether uneven. In the interest of time, I'll focus simply on the state police power cases where most of the confusion arises. Consistent with the underlying theory of political legitimacy that I sketched earlier, the police power we enjoy in the state of nature, Locke's executive power, and then delegate to government, is mainly there to secure our rights. Thus, it's bounded by the rights that there are to be secured. The question then, from Lochner to Lawrence, and in many cases in between, the question should be what rights the state is securing by a law criminalizing, say, the sale of contraceptives or marrying someone of another race. If the state can point to no such rights, that settles it. The judge doesn't have to discover any unenumerated rights. It's the state that has to identify rights to be protected under the police power. As with enumerated powers, then, where there is no power, by implication there is a right. Hamilton, Wilson, and others objected to adding a Bill of Rights because they saw it was impossible to enumerate all of our rights and dangerous to enumerate only some. Thus, structural limits were meant to secure our liberty, power pitted against power, the enumeration of federal powers, and later a narrow reading of the state police power consistent with the privileges or immunities we enjoyed as citizens of the United States. Indeed, did we have no rights prior to adding a Bill of Rights, or lose rights when we added one? That's the implication if judges are to secure only enumerated rights, as many conservatives today, including Justice Scalia, have argued. The Ninth Amendment was written to dispel that reading. The textualists can hardly ignore it or ignore its complement vis-a-vis the states with the Privileges or Immunities Clause of the 14th Amendment. So why do so many conservatives indulge that reading? Responding, understandably, to the perceived judicial activism of the Warren and Burger courts, Bickel, Bork, Scalia, and others focused on the counter-majoritarian difficulty and the need, accordingly, for judges to indulge the passive virtues. But in so doing, they ignored the majoritarian difficulty, which deeply concerned the framers. The framers stood for liberty first, majoritarianism second, as only one means toward liberty. Their main means was structure, including revised, principled federalism. We tend to think of federalism as states protecting liberty vis-a-vis the federal government, but it cuts the other way too, protecting against grassroots tyranny. And that's what Justice Scalia too little appreciated. His work for securing originalism was invaluable, and he will be long remembered for that. But let's secure the whole of originalism. Thank you.
Well, good afternoon. It's great to be here. Judge Pryor came and visited the Harvard Law campus back in my day, and I don't think he was a judge yet. I think he was rumored or something. It was controversial. A lot of the Harvard faculty thought that he would commence a reign of terror on the bench, and once I heard that, that was probably the best seal of approval I could possibly imagine, short of an endorsement from Justice Scalia himself. And sure enough, he's proven to be a great judge, so it's an honor to be here with him. You know, I think about Congress's role in the constitutional system. Think of a little anecdote. A constituent asked me about an issue with municipal trash cleanup in their neighborhood. And I responded, I said, it's an important issue, but I'm your federal representative in the U.S. Congress. We deal with the federal issues. And she said, yeah, I know. I just thought I'd start at the bottom of the totem pole and work my way up. And the thing about that is there's a truth to that, not just because Congress is a punching bag, but I think Congress stands today as the weakest of the three branches in our constitutional system. And I think Justice Scalia was always very, very articulate about identifying the structural Constitution as the #1 protector of individual liberty, that you would have these different branches and they would compete with one another. They'd be zealous about guarding their power. And that, even more than the Bill of Rights, was how we would preserve and protect individual liberty. And it's interesting, the founders, if you read Madison, you read the Federalists, we hear about 3 co-equal branches of government. The founders didn't envision them to necessarily be equal. I think they envisioned them to compete, but Madison said in Republican government, the legislative authority necessarily predominates. And in fact, although the Revolution was a revolt against executive authority, the Constitution, the impulse of that was they saw runaway legislatures in the states at the time. And so they wanted to have a government of, by, and for the people, but they didn't want it to simply be a tyranny of the majority. So they knew that the Congress would be powerful, but they wanted to have other branches that would also check it. But even with those checks, they just thought that the branch that was closest to the people, at least the House, would have the most power. And of course, if you look at the original constitutional design, just look at Congress's power, the power of the purse, obviously the power to legislate. You can prevent a administration from stocking with personnel by not confirming people. You can impeach civil officers, the president, vice president. You can circumscribe the jurisdiction of the courts. You can even abolish, you don't even need to create lower courts, you can abolish them. So they understood that the presidency would be powerful, particularly in foreign affairs, but it was really more of a check on the legislature is how they envisioned it. Yes, Hamilton said an executive can undertake extensive and arduous enterprises for the public benefit, but if the Congress isn't providing provisions, providing funding for those enterprises, then they're going to amount to nothing. And the courts, of course, Hamilton said, were incontestably the weakest of the 3 branches of the government. They have neither force nor will, but merely judgment. An important role, absolutely, but you're not able to legislate from the bench. And the current practice, I think, to me, the executive by far is the most powerful. Then I would say the courts. I mean, the courts probably have as much legislative authority as we do. Certainly, they have more power over the Constitution. Part of the reason the executive has gained so much power is through congressional neglect. Congress will legislate and they'll say, well, we really can't deal with these thorny issues, so bureaucracy, you figure it out. And the bureaucracy effectively legislates very important policy determinations. I mean, the Hobby Lobby case that went to the Supreme Court, that was not written into the statute. That was an HHS regulation. And obviously, congressional neglect, I think, has also paved the way for administrative overreach. And so a statute is ambiguous, or even a long statute that's been on the books for decades, the administrative agencies, the executive branch going beyond that, legislating vast new policies that have a tremendous effect on American society and the American economy. My first State of the Union, when I got elected in 2012, President Obama came and he said, Congress, I want you to do what I say, but if you don't enact it, I'm going to do it on my own. And, you know, we had just gotten sworn in a couple weeks ago. I was like, that's not exactly how it's written down in the Constitution. But the thing that bothered me the most about it was not that the president was asserting that authority, because the founders presumed that each branch would try to exceed its constitutional limits. What bothered me was I looked to my left. Every single Democrat in that chamber stood and cheered him when he said that. So they were willing to put their personal political viewpoints ahead of their duty to defend their own institution, which I think is defending the Constitution. So it's a problem in both ways. The executive branch and congressional accountability, we did this with the IRS in terms of dealing with the targeting. Obviously, the Justice Department was not going to do anything. We knew that from the beginning. But at least conduct oversight, at least get documents. They destroyed emails that were subpoenaed. The commissioner made multiple false statements. He's admitted the statements were false. They didn't do basic due diligence, like even look at Lois Lerner's BlackBerry. But what happens? Nothing. So to me, the lesson that the bureaucracy takes from Congress's fecklessness is destroy the stuff. Don't worry about it, because there's nothing going to happen to you if the executive, at the head of the executive branch, concurs in kind of doing what you're doing. Of course, the courts have also helped the executive become more powerful by deferring to what the administrative agencies do. To me, I think you should apply the law as it's written and not defer to the executive branch, because that allows the administrative state to get bigger. So I think that Justice Scalia, nobody has been more influential for law students, for lawyers, for judges, if you're on the center right. I just wish his wisdom would make its way more into the halls of the United States Congress, because Scalia understood that you have to defend your own turf. One of the things that frustrates me is some of my colleagues will say, if we're debating a bill, is it constitutional? Do we have this power? Does it conflict with the bill? Well, we'll let the courts figure that out. We do whatever, we vote for whatever we think is good, unless and until the courts stop us. Well, the problem with that is that the courts can only decide cases or controversies. So basically, anything that would not lead to a lawsuit, you're basically saying there's not going to be anyone that's going to stand up for the Constitution. Our duty is to defend the Constitution and act in conformance with the Constitution. So I've always said, if there's a bill that's not constitutional, my duty is to vote against it, regardless of what the courts may or may not do. It's not just the Congress. I mean, President Bush, when he signed McCain-Feingold, he said, I think it's unconstitutional, but we'll let the courts figure that out. That's not the way you're supposed to do it. If you're not convinced it's constitutional, you got to err on the side of exercising your authority to defend the Constitution. So I think Justice Scalia would really, I think he was kind of frustrated with Congress. Our big way to defend our powers, the Obamacare program took funding that really was never appropriated. So rather than us, that's our core power, the power of the purse. What we did is we filed a lawsuit to try to vindicate that interest. And, we were able to move the ball forward a little bit, but I think Scalia would look at that and say, why are you running to the courts to do this? You guys should defend it yourself. You have the power. You have the power of the purse. You have the power to not confirm people. You have the power to impeach civil officers. Why don't you use those powers rather than running for the court? And I think at the end of the day, we're in this budget problem where we do these big omnibuses and we're not able to really solve that. So we're not willing to take any political risk to really defend our turf, I think is the thing. So it ends up going, let's file a lawsuit and let's do it. So it's an honor to be here. Justice Scalia really was a man for all seasons. He was one of the few people to really make an indelible mark, not only on the law, but on political philosophy. I just wish everything that's been discussed on this panel and this conference could make its way into the halls of the Congress, and that we'll reclaim our constitutional authority and get the constitutional system back into its proper form. Thank you, guys.
Okay, I want to first invite our panelists to respond to each other from your seat. Hopefully, your mics are now live for you to do that. I would expect that perhaps Professor Baker has some things he wants to say in response to
Well, Roger thinks I'm going to attack him, but Roger and I debate every year, but I didn't find much to attack on Roger. But I want to follow up with what Jonathan Turley said about Prince, and it was really important that you did what you did on Prince, Jonathan. I just wanted to add that if you look at the separate opinion by Justice Breyer. The amazing thing is that Justice Breyer says, well, you know, I don't see why the federal government can't just order local officials to do it. It's more efficient. In fact, they do it in Europe that way. It's more efficient. Now, if you read the Federalist, you will know that the crux of the whole problem and why we changed from a confederation is, in fact, in Federalist 15, that whole point, you can't have one government telling another government what to do because eventually it won't work. See Brexit.
I was going to add, I don't disagree. Roger and I agree on most things anyway, so that's not a surprise. But the one area of Scalia's legacy, which I do find problematic, it was his support for Chevron. That it was sort of anomalous. He continued to support the idea of Chevron, even as we had this rise of sort of the fourth branch, the rise of the administrative state. I think that he certainly indicated some misgivings about Chevron. But that was always the one part of his legacy that I thought was most sharply discordant with his views, particularly with regard to sort of formalism. But that's what I would add to in terms of a criticism.
Yeah.
I would just say on that, as Justice Alito said this morning, he was actually changing on that.
Right.
One. And two,
Right.
Roger mentioned the, quote, post-New Deal originalism. Although he didn't specifically articulate it this way, once you have the 17th Amendment, it changes. The Senate is no longer a protector of the states. That's what built the administrative state. And he's trying to figure out, how do you deal with this? How do you draw lines? And will the courts then end up replacing the administrative agencies and running everything? What most people just don't understand, especially populists, is that that was a real structural protection that is the driver behind the administrative state and the uncontrollable budgets. That is just not widely known. He understood that. And with that, it is very difficult to reverse the dynamic, and he didn't think the courts were in the business of reversing that dynamic.
Roger.
Yes, the reason Jonathan didn't do the administrative law side of things is that I had 8 minutes.
That would have required 18.
And I'm not surprised that John Baker didn't find anything to disagree with because I uttered only true sentences.
What?
Uttered only true sentences.
True.
But
Well, this is breaking down fast. I think we'll start with questions from the floor. Now, I'm going to begin with my usual admonition. These are the panelists. They were invited to be our speakers today. We appreciate your presence here. We love to have your questions, but you weren't asked to be speakers today. So I want to ask for questions, and you can introduce it with a little bit, but please keep it as a question.
Ilya Shapiro from the Cato Institute, and to the extent you enjoyed Roger's essay on Scalia's originalism, I had to edit it, so you're welcome. Just kidding. I only had to introduce a couple of commas. It was very clear. But anyhow, I'd like to invite speculation on Scalia's vote in Raich. Was that his accommodation of the post-New Deal regulatory state? Was it the drug war exception to the Constitution? Something else?
I think it was his failure to agree with Justice Thomas on how properly to read the Commerce Clause. And I don't think
Or it was the necessary and proper clause.
Well, both of them. I mean, and I think that was, it goes back to what I said, the New Deal is a watershed, but it affects not just the interpretation per se, it affects the dynamic. And I think he felt that there was no way to undo that. I mean, when we would bring this up at sessions, he would say, you know, well, that's water under the bridge. And
that's what he said when I invited him over.
look, he fought more battles than anybody else. And I think that there were just some battles that he didn't. I mean, early on, when we would cover FLAST, those of you who were in this morning, you heard Justice Alito and how Justice Scalia excoriated him for not saying that Flash should be overruled. Early on when we were teaching, I said, why don't you overrule Flash? And he said, well, my colleagues will never do it. And he wasn't even arguing for it at that time. And then he changed over time and he was starting to argue for it. Look, it comes down to the votes on the court. If there aren't votes there to do something, it's not going to get done. I mean, one time I had a case up there and he said I could ask him afterwards why they didn't take it. And, you know, the votes weren't there is what it came down to.
Well, just a quick response to Ilya's question. It's hard to know what motivated Scalia in rage, but if the Federalist is one of the central topics on this panel, if you're talking about the General Welfare Clause, the Commerce Clause, and the Necessary and Proper Clause, which are the three clauses through which we got Leviathan, then you can do no better than to look at Federalist 41, 42, and 44 respectively.
And 45.
Exactly what Madison thought those clauses were all about. And they weren't about allowing a decision like came out of rage.
But when not just people on the left, but overwhelmingly people on the right do not understand our structure. I mean, the latest vote or latest poll on the Electoral College is the vast majority of American people want to throw it out. They have no idea of what that will do.
Well, most people don't know when the War of 1812 was fought.
And they don't know what it did.
We're going to take a question from the right, the side that's to my right.
Todd Zwicky from the Antonin Scalia Law School. And if you know me, I will show restraint and not ask about the 17th Amendment. What I will ask about, though, is I was struck by Congressman DeSantis' remarks on the Federalists, and I was thinking about Federalist 62, where they make the argument for bicameralism, premised on the idea that the legislature is the real threat, and the remedy for this is to break the legislature into two parts and use bicameralism. I'd just be curious about the panel's reflections on bicameralism in the modern age as perhaps it relates to Federalist 62. It's not a well-formulated question. Maybe you can do something interesting with it.
Well, at least it was a question.
What I've seen, I think, that's been different than how Madison and Hamilton would have envisioned it is they really thought that you would side with your institution. But in some of the budget fights that we've had, you know, the Congress actually passed the unified budget for the first time in, I think, 15 years. Last year, 2015, we started to do appropriation bills in the House, and it got to the Senate, and Harry Reid would filibuster the bill even being brought up. Basically, no agencies funded, go all the way to the deadline, and then force some kind of omnibus or continuing resolution. And what they were doing is you had a minority in the Senate siding with the executive branch over, you know, a core power. And I think that as, you know, we weren't able to, the senators weren't able to figure that one out, but that is not, I think, what we should have been doing. They should have been standing with the House to try to rein in the president, I think is how it was originally designed.
Yeah, I would add that I think that I'm a Madisonian scholar, so it's hard for me to say that he got anything wrong. But the one thing that I think he would have been astonished by is, in fact, the 2012 State of the Union that Congressman DeSantis was talking about. As a Madisonian scholar, I was in disbelief as the president stood up and said, you know, because you've not carried out my reforms, I've decided to circumvent you and make you a functional nonentity. And he got rapturous applause from half the chamber. And I think that Madison truly believed that institutional interests would overcome political alliances in that sense. I had the honor of representing the House of Representatives in the ACA lawsuit. And I have to say, I was surprised to see the level of Democratic opposition. We were fighting over the power of the purse, the defining power of Congress. And so there is a strange thing going on that I think that Madison did not anticipate with regard to who the members are and how they've changed. And I think that is different. You know, I went to Congress when I was a 14-year-old page, and there were people there, giants, who fought for the institution, not just people like Byrd and Javits and Moynihan. They often put away their political alliances and fought for the institutional integrity of both chambers. That's what's missing often today, and I hear that in the words, in your words. Yeah.
And let's wait 2 months and see. I mean, I guarantee you'll have the Democrats much more receptive to these arguments, and I think it's an open question about how Republicans are going to respond if there is similar actions taken. Are we going to defend the institution when the politically easy thing to do is probably just to fall in line behind the president? And so hopefully the rubber doesn't meet the road on that and the president conducts himself accordingly. But I think that it'll be interesting to see how it shakes out.
If I could just say, I'm so encouraged to hear the congressman's comments about reclaiming the lost power of the legislative branch in this country. You know, when I talked about the dozens of lawsuits we filed, it was really because we were forced to file those lawsuits because it was very clear that the executive branch had overstepped its authority. And when the president stands up and says, I literally have a pen and a phone, and I'm going to do what I want to do, and he's being applauded by Congress, it's really disturbing. And so I really, if you don't get anything accomplished in the next 2 years, we're looking for a candidate for AG in Florida in 2018. And you'll enjoy that job.
Well, but I will say, though, I think part of it is political. We saw with the election outcome, some people were shocked. They thought the Democrats would never lose the White House again, so I think that was part of it, that, hey, the Republicans aren't going to be in that spot, so us doing this, it's not really setting bad precedents. Now what happens? You support the bad precedent, and who ends up president? Donald Trump, who many of them are concerned about. So be careful. Never invest power into a person who you would not be comfortable if your greatest enemy exercised that power.
On that point, I just want to add that Professor Turley was the one who warned liberals before a House committee that if you don't stop this president, you're going to get a Republican in here one day who's going to do the same thing.
Question?
Thank you, Your Honor. I want to reassure Professor Baker that Idaho loves the Electoral College. We don't want to give it up. But with 1.5 million citizens, we have a problem with overregulation. We have 722 sets of regulations in Idaho that's pretty much strangling us. And so without the senatorial check, and given Chaha, which the case got rid of the legislative veto for a unicameral action, Idaho just passed a constitutional amendment to have a bicameral legislative veto. And so since we got the 17th Amendment, is the legislative veto viable at the federal level on a bicameral basis? And I'm also wondering what Roger Pallan and Professor Baker in particular have to say about that.
You want a legislative veto? 2 houses? Is that
Oh, I would love to have it myself, but no. Yeah, the two houses together could get rid of executive branch
Okay,
rules.
but here's the problem with many people on the left and the right. They see a particular problem, and they look only at that problem, and they come up with a solution for that problem without thinking about the consequences, the new problems they're creating. You have to look at the whole body together and figure out what you're doing. Remember, the 17th Amendment was passed with virtually no opposition by populists on the right and the left, except that the populists on the left knew what they were doing. They were out to destroy separation of powers. Nobody made the arguments, structural arguments. And they made the same arguments that are today being made for term limiting members of Congress. Okay? They thought it would bring senators closer to the people. Nothing could be further from the truth. So you have to know something about the Constitution before you keep changing things in it. It's a matter of looking at what worked and why it worked. Or to borrow a phrase, what really did make us a great country.
Justice Scalia often said that the 16th and 17th Amendments, both passed in 1913 at the height of the Progressive era, were the key to understanding the emergence of Leviathan. However, neither of those amendments expanded the power of Congress. Congress didn't have a bit more power afterward than it had before, except as a practical matter, a political matter, that is to say. Now you've got political forces calling for the demise of the enumerated powers doctrine. But it fell finally to the court in 1937 to expunge, to eviscerate that doctrine.
But they would never have done it if senators were still protecting states because they wouldn't have put up with it. The idea...
Political point, not a legal.
No, but it changes the dynamic of power. What the Federalists explain is human nature and what motivates people. Today we think policy, well, wait a minute, policies are executed by human beings, and what are their motives?
Take another question.
Thank you. I used to be the chief of federal litigation for Miami-Dade County, and I'm now a city attorney. And I teach state and local government law. And
What's your name?
Craig Lean. One issue that I see related to federalism, I wanted to ask you about it and what Justice Scalia thought about it, is, you know, in the early 1900s, there was a case, Hunter v. City of Pittsburgh, that talked about how states really have authority over their local governments. And what's occurred to me and to many of my students when I teach them about state and local government law is that the federal government exercises a lot of authority over counties and cities, both through 42 U.S.C. Section 1983, through a number of other acts and statutes, and through the administrative agencies, which I'm not making a normative judgment on that, but I find it very interesting because if you truly have federalism, but the federal government really is the one, for example, regulating city police departments or state or county police departments and not the state, do you really have federalism?
Okay.
You do, because as I said in my formal remarks, federalism cuts both ways. It's not simply the federal government has limited power and the states have the balance of power, Federalist 45. It's rather that the Civil War amendments changed that arrangement fundamentally. Now you've got federal power essentially to negate state actions that are in violation of their own citizens. That's altogether different from federal power to give us Obamacare, whatnot. It's federal power to negate states that are running amok. And that's the other side of federalism that the Civil War amendments brought into being. And that's the side that so many conservatives find uncomfortable because they think of it as empowering the court to find unenumerated rights. What I tried to argue was that, no, it empowers the court to tell the state what right is this police power protecting. And when you look at everything from Lochner to Pierce v. Society of Sisters, Meyer v. Nebraska, Griswold, Lawrence, you find that these are essentially morals arguments. They're not defense of rights of individuals.
Thank you, Judge. My name is Justin Pearson. I'm an attorney at the Institute for Justice.
Okay. Could you speak a little closer to the microphone so we can hear you better?
Anyway, I'm an attorney at the Institute for Justice. My name is Justin Pearson, and my question is directed at Congressman DeSantis. And I want to preface this by saying that, Congressman, I really appreciated what you said about the duty of elected officials to not support unconstitutional legislation. My question to you, Congressman, is whether you think that is mutually exclusive with the role of courts to use the Constitution to serve as an additional bulwark against legislative encroachments, as Hamilton promised in Federalist 78, when elected officials fail to fulfill that duty.
Oh, no, absolutely. I mean, I think that, and Justice Scalia would say this, look, this idea of judicial review, it's not that we're smart or philosopher kings and know these great policy questions. This is a lawyer's job. You have a constitutional text, you have a statutory text. And if they're harmonious, then fine. If there's a conflict, then your job is to identify that conflict and, of course, prefer the fundamental laws represented in the Constitution over the transient impulses of the people as represented in a statute. So that is absolutely legitimate. But this is something that these cases are brought to them. They can't go out and do it, and they can't go beyond what the case is. And I would also say that just because a court has found something to be constitutional, if you honestly as a legislator believe that it is not constitutional, that the court got it wrong, to me, I still think you have a duty to vote against the statute. Now, many people say, oh, well, the court ruled, I'm fine, and you won't be criticized for that, but courts don't always get it right, and we have to render our own judgment. It doesn't mean you don't follow court decisions, but at the same time, you know, we're not under any obligation to vote for statutes that we honestly don't believe are constitutional.
I would just add that a lot of times people don't realize that you can have two separate viewpoints altogether between the Congress and the court. That is, when the court rules on something as to whether it's necessary and proper, they're ruling as to whether the Congress could find this necessary and proper. It doesn't mean as a member of Congress that you have to say it's necessary and proper, and that is a constitutional issue.
Next question.
Roman Buehler with the Madison Coalition. 25 years ago, I was Newt Gingrich's first committee counsel, and we thought Congress could fix everything. But I'd be interested in the opinion of the panel about an effort that's now going on, coming up from the states. There are now 900 state legislators and 6 governors, and 19 state legislative chambers, and the Republican National Committee's unanimous endorsement and language in the platform, in the Republican platform, for a constitutional version of the REINS Act that almost every House Republican voted for, that would require that Congress approve major new federal regulations. And the idea is that in the same way that states were able to force Congress to propose the Bill of Rights without a convention, and more recently the 17th Amendment and presidential term limits, that pressure from the states could persuade Congress to do what's in its own interest and reclaim the executive branch power, the Article I power that's been stolen by the executive branch. Your thoughts on Regulation Freedom Amendment and the strategy? Thanks.
I'm generally against amending on issues like the REINS Act because we should just pass the REINS Act. I think that it's important to use the Constitution for stuff that we cannot achieve legislatively. I testified recently in Congress asking them again to bring up the REINS Act. I think the REINS Act is a very useful tool to get Congress back in the business of governing. I mean, there's a sort of not so noble lie that Congress is actually governing when most 99% of the agency decisions are not being reviewed. They're being increasingly done independently. And I think that that is a serious danger for a democratic system. More and more of our decisions are being decided by this insulated group of agency officials. The public has no interaction with them, doesn't even know who they are. I mean, even trivial things like some unknown office declaring that the Redskins can't use the Redskins name. Now, this is a raging debate. I'm not involved. I'm a Bears fan. But the fact is, you had this unknown office step in and say, all right, we're going to settle the question. You don't have trademark protections. You can't use that name. It's an example of what we talk about with the fourth branch. Largely, that's insulated from Congress. Congress doesn't have the ability, the staff, to seriously look at agencies. That would change if we have something like the REINS Act, and I think you just pass the act or something like it rather than amend the Constitution.
I'd support a constitutional amendment of 4 words, and we mean it.
Next question.
Hi, I'm Warren Belmar, and I'm a recovering attorney with one question. Is there any vitality left to Schechter Poultry? And if not, why not?
Well, according to Justice Scalia, there wasn't.
It was the
Is there any
limitation on
continuing
delegation
vitality to Schechter Poultry?
He used to say that was the only case, and that's companion case in which they ever applied that, and that wouldn't be applied again. But that's before he started rethinking Chevron, so there's no telling what would have.
Well, it's the only limit we had on delegations of broad general authority to the executive branch, and something that might still have some vitality.
Okay. Let me read this first. So buses to the Gaylord for the annual dinner can be boarded on the DeSales Street side of the hotel. You can access DeSales Street by exiting the hotel at the door to the outside near the gift shop. Please ask a staff member. They can direct you. Buses will leave for the Gaylord from now until 6 p.m. For the return trip, buses will depart at the conclusion of the dinner and then every half hour with the last bus loading at 11:30 p.m. So will you please join me in thanking this panel for its presentation?
It's always incredible to listen to you. I feel like I learn more.